Judge Barrett, good to see you again.
Likewise.
Before I begin my comments and questions, I think there was at least an implication from what was just said that you would not be sensitive to the need for equal justice for all under the law, for all peoples in America. Would you like to respond to that at all before I go ahead?
I am fully committed to equal justice under the law for all persons. I am fully committed to enforcing all laws to prohibit racial discrimination. In my private life, I abhor racial discrimination, and obviously for both personal reasons and professional reasons, want to ensure that there's equal justice for all. And, you know, all of my children, I think, have made an escape, but if they watch this one day, I would want all of them to know, and especially Vivian and John Peter, that I unequivocally condemn racism and want to do everything that I can in my own capacity, personally and as a judge, to end it.
Thank you. I appreciate you making that point. I find it just incredible that a mother of children of different races could be accused of not being sensitive nor willing to protect the rights of all under the Constitution. Before I go on with my questions, once again, it's happened both 2 days ago and yesterday and again today. There's a couple of things I think that need to be set straight in the record. First of all, once again today, it was said that we should not be holding these proceedings because we should be dealing with the pandemic. Well, first of all, the Senate can do more than one thing at one time. Secondly, as I indicated before, we've put over a $500 billion package of relief dealing with most every important and significant aspect of our need for COVID response on the floor. It has been filibustered by the other side. The president has made an even larger offer back. That has been flatly rejected. And we have had an announcement recently by the leader of the Senate, Mitch McConnell, that we will vote again next week on the issue to see if there is some way we can get an agreement to move forward. But the argument that we should simply ignore this important nomination because of that holds no water. Secondly, another of the major points that this entire hearing was started out with on the first day was that people should be scared by these proceedings because they will lose coverage, health care coverage for their pre-existing conditions. That has been, again, run out here today, time and time again. And I'm not going to ask you to go through that again, but I'm going to make a couple of comments about that. As I said earlier in these hearings, even back when we were debating Obamacare, there was no disagreement about covering pre-existing conditions. And in every proposal from our side since that time, coverage for pre-existing conditions has been included. It is not something that there is an effort to or a willingness or a desire to eliminate in terms of protection, and it is not at risk in the Supreme Court case, as you have, I think, very clearly described in your testimony, Judge Barrett. And finally, with regard to that, if those assurances and those facts don't make it clear, Senator Tillis has introduced legislation called the PROTECT Act, which will put into law, once again, protection for pre-existing conditions in our health care coverage. And every one of my colleagues on the other side of the aisle voted no to stop that from moving forward. It's there. The bill, the PROTECT Act, is in the Senate. We can vote on it if we can just get permission to proceed to it from our colleagues. So this notion that pre-existing conditions is somehow at jeopardy is simply rolling out yet again in this campaign cycle, another one of the arguments that doesn't hold water. Now, I do want to move to some questions for you, Judge Barrett, and again, after it was extensively discussed yesterday and the day before, you have been attacked on the basis of concerns about your willingness to follow precedent and stare decisis. In fact, one of my colleagues, if I heard it right, said he thought that you may participate in issuing in a whole new era of judicial activism in overruling precedent of the courts and basically pushing an agenda that you won't admit to having. I know you answered this a lot yesterday. We're going to go through it again. One of the things that you were asked about extensively was this, I think, 2013 law review article where a sentence was plucked out of it that you feel was not correctly reflective of what you said and how you feel. Would you like to take an opportunity to clarify that for us?
Sure. That article was responding, so as I've said a couple times, the Supreme Court gives different precedential strength to constitutional cases than to statutory cases. And that article was responding to arguments that either stare decisis should be eliminated altogether or that it should be absolute. And I was taking the Supreme Court doctrine as it exists, where constitutional cases are not absolutely insulated from overruling, which is the position that every Supreme Court justice of whom I'm aware has had. Sometimes you do have to overrule cases, otherwise we don't have Brown versus the Board of Education. And I was just identifying some of the virtues of that presumption. So I was defending in that article the current Supreme Court doctrine of stare decisis, and I very clearly said in that article that you can't just impose a new vision with votes, that you have to take reliance interests, and that always lack of certainty about how the stare decisis calculus runs counsels in favor of keeping the status quo.
Well, thank you. Now, I found it amazing that you would be accused of being a judicial activist because you are a textualist and an originalist, as I understand your testimony and your record and your writings. And I'd like to just look at a few of your writings. You have described stare decisis as a fixture of the federal judicial system. You have stated that the Supreme Court, that you recognize that the Supreme Court follows a presumption that precedent will stand and that the court does not depart from that presumption unless the precedent is not only erroneous but unworkable, correct?
And not only erroneous and unworkable, but also has to take into account reliance interests and those other factors as well.
Yep, that was actually next on my list.
Okay, sorry. I thought you meant unworkable was enough.
You anticipated that. And you have spent a lot of time, and I won't ask you to do it again, going through those requirements that are in place before a judge or a justice would seek to become an activist in the sense of overturning existing precedent of the court. And you've also said that partisan politics are not a good reason for overturning precedent. I assume that goes without saying, correct? Let's look at those are some of your writings, and you've written much more, but let's look at some of the case law. You've got a pretty significant record now in the Seventh Circuit. You have, as I see it, a pretty solid record there of following precedent. The first issue is in 2019, you had a discussion with Judge Amul Thapar.
Oh, yes, Judge Amul Thapar.
Okay, and I think could you please explain that conversation? It related, I think, to a case where you were clarifying that even though you disagreed in a previous circumstance relating to it, that you would follow precedent, or do you recall that conversation?
I recall the conversation. We did it for a professor in the political science department. It was primarily an undergrad audience, and we answered questions back and forth on a range of topics. I don't remember the particular.
Okay, so this was not a case, it was a scenario you were asked about in that conversation.
Oh, okay.
And you made the clarification that in that scenario, you would decide a case or a case consistent with the way the majority did and not with your own view if the precedent required it.
Oh, so if I had dissented the first time around and lost, and then when
that's apparently what that was all about.
Okay.
So let's talk about a couple cases. In Price versus the City of Chicago, you joined in affirming opinion over a district court's dismissal of a suit by pro-life activists. Do you recall that case?
I do.
What role did precedent play there?
Precedent controlled a case called Hill versus Colorado. The bubble zone ordinance at issue in Price was nearly identical to the one that the court had upheld in Hill.
And even though in this case you ruled against a pro-life interest in following precedent, correct?
Correct.
In Lett versus the City of Chicago, you applied the Supreme Court's test for evaluating restrictions on public employee speech. Do you recall that case? Yes. And again,
Yes.
you followed the precedent. In Chazen versus Marske, M-A-R-S-K-E, the Seventh Circuit held, in light of the United States v. Mathis and a subsequent Seventh Circuit decision, that a petitioner's prior convictions on a burglary no longer qualified as predicate offenses under a certain criminal act. Again, following precedent of the Supreme Court and the Seventh Circuit. I'm just picking out a few. You've got a very full record of these. In my view, I only found one case where you actually did not follow Seventh Circuit precedent. And that was the case of Groves versus the United States. And I don't know if you recall that case, but
I do.
why didn't you follow Seventh Circuit precedent then?
So in that case, there was precedent that was old, on point, and the Supreme Court had issued a series of subsequent decisions which called our prior precedent into doubt. And so the Seventh Circuit has a rule called Circuit Rule 40E, and when we conclude as a full court, you circulate an opinion to the full court to say, I think our precedent should be overruled. In this case, because it had fallen out of step with later developments in the Supreme Court, I circulated that precedent, or the opinion pursuant to 40E, and the full court agreed. So we overruled precedent.
So the way I would summarize that is that you, the court, with your support, overruled a Seventh Circuit precedent because a Supreme Court precedent overruled that. Pretty closely?
Not directly overruled it, but the Supreme Court precedent
Was inconsistent with
undercut it.
So you were
Undercut it.
following Supreme Court precedent to take that action.
Yes.
All right, let's just look at your cases. And I'm going to go through some statistics here. You know, statistics sometimes get outdated or what have you. So if these are not accurate in your understanding, please tell me. But what I have before me tells me that you've authored 79 majority opinions since arriving at the Seventh Circuit. Is that a correct number?
I don't know. So I will take your word for it. I think
All right, well,
yeah.
that's what my information says.
Okay.
And it says that you've participated in the disposition of 922 appeals. Does that sound approximately accurate?
I think I have, the numbers that I have looked at recently suggested that I've participated in 600 panels that were appellate, but close to 1,000 matters, which would include things like stay, certificates of appealability, stay applications, et cetera.
All right. And my understanding is, and again, these statistics might vary a little bit because the numbers are a little different than you say, but I think this is pretty accurate, that your majority opinions have been unanimous 95% of the time. In other words, almost always when you join a majority, it's a unanimous conclusion of the court, or of the panel. Is that correct?
That's my understanding. I've seen that statistic.
Well, the statistics I see say that it's 95% of the time that it's unanimous for the decisions of the panel. According to CRS, Congressional Research Service, in all the cases you heard resulting in a reported opinion, you've only dissented 1.84% of the time. That ranks you 6th among the 11 active judges of the Seventh Circuit, which is right about in the middle. This report also says that your reported majority opinions drew dissents 6.41% of the time, which ranks you 6th among the 11 panelists, or of the 11 active judges, right about in the middle. And it says that the reported majority opinions drew separate writings or concurrences or dissents 7.69% of the time. That ranks you 8th among the 11 active judges of the Seventh Circuit, which means your opinions were some of the least likely to draw a dissent or a concurrence. The point of all these statistics is this is not the record of someone who is an activist in overturning precedent. This is the record of someone who follows precedent. And I just want to thank you for being that kind of a judge, because that's one of the reasons I'm so glad to support you as we move forward. Now again, unfortunately, today, once again, and I thought we had this resolved yesterday, you've been challenged on what you knew about the president's positions on various issues and whether that influenced your positions. In fact, I think it was even implied that a law review article you wrote that was probably written before the president was even president was something that you were influenced in writing because you knew what the president thought. In any event, we're going to have to go back again and ask you these questions about, you've already said yesterday that the president didn't talk to you, his staff didn't talk to you, no one talked to you about Roe versus Wade, Obergefell, or California v. Texas, and you made no commitments on those 3 cases.
I made no commitments on any of those cases or on any other case.
That was my next question. Because today it's been implied that you've basically just been following the president's statements, his tweets, even things that he may have felt or believed before he was president, and trying to make your decisions consistent with that. So once again, has the president or his team or anyone talked to you about any case or received a commitment from you about how you would rule on any case?
No, Senator Crapo.
All right. I hope that we can once again put that one to rest. And could you also once again restate, is anybody above the law in the United States?
No one is above the law in the United States.
All right. Thank you very much. I told you yesterday before I quit that I was going to ask you a few softballs.
Sometimes softballs turn out not to be softballs. Go ahead.
Well, I think this will. I just want to ask you, I'm going to go, these are some of my hard balls. I'm going to leave those because I've only got 3 minutes left. I just want to talk to you for a minute about academia. What led you to your decision to move out of practice into academia?
Well, when I was in law school, I thought I might like to teach someday because I really like teaching. I considered being a teacher. I mean, being a secondary school teacher was actually one of the things I thought about too in college. As I said in my speech at the announcement of my nomination, that my mom was a teacher and my dad was a lawyer, and so combined that might explain how I wound up being a law professor. So I loved the idea of teaching students. I liked the idea of communicating with clarity, complicated doctrines to them to help them. I have very much enjoyed, teaching the 2,000 students that I've taught and mentoring them as young adults just embarking on their careers, and in many cases for those who have not had much time between undergrad and law school, even kind of launching their lives. It's been a really rewarding experience.
Well, you've obviously been very influential in that because so many of your students and your colleagues speak so highly of you. You actually also anticipated 2 of my other questions about it, so I only have one more to ask, and that is, what was your favorite class to teach?
Oh, it's hard to pick a favorite. It's like asking what's your favorite child, who's your favorite child. I really enjoyed teaching so many classes. I mean, constitutional law and federal courts overlapped directly with the things I was writing about. I taught evidence mostly just because they needed somebody to do it. And what's funny about that is, I didn't do scholarship. I didn't write scholarship about evidence. It wasn't part of my scholarly interest, and I was doing it as service. It's called a service class just because you need someone, everyone wants to take it. It turned out to be really fun to teach just because it was fun to be able to engage students in interactive exercises, and I could use movie clips to do it, and it turned out to be a very fun class to teach, even though it didn't overlap with the things I was writing about.
Well, thank you very much, Judge Barrett, and it is an honor for me to be able to support you for this nomination.
Thank you, Senator.
Thank you.